The title of this video is How to Protect $5 Million Plus in 2026, the Offshore Trust Strategy. And in the next 60 seconds, I'll show you the quiet mistake that turns "I'm probably fine" into "I just paid a 7-figure settlement." So here's the problem. When you cross $5 million, you become collectible. You don't need to be reckless. You just need to be visible. Business owner, real estate investor, operating company, staff, customers, tenants, partners. In 2026, more disputes turn into lawsuits, and lawsuits turn into leverage hunts. So here's the promise. By the end of this video, you'll know how sophisticated business owners and investors legally structure offshore protection so a plaintiff's lawyer can't simply push one button in a U.S. court and reach your reserves. And here's the path. We'll cover 1, how modern lawsuits actually take money. 2, why common domestic plans crack under pressure. 3, how an offshore trust changes the bargaining power. And 4, the exact way we structure a Cook Islands trust with a Cook Islands LLC inside of it so that you manage it when the waters are calm and our licensed bonded trustee company law firm steps in only if a lawsuit turns into a real threat. Now here's the micro cliffhanger. In a minute, I'll give you the 30-second exposure test that you can do in your own head and see if you're already the easiest target in your circle. Okay, quick credibility, then we move. I'm the CEO of the Lawyers Limited Law Firm and our brand Asset Protection Planners. I've been in the asset protection field for 34 years and setting up Cook Islands Trust for nearly 30 years. In fact, I believe our firm has set up more Cook Islands Trust than any firm in the world. And I say that the way you'd say you've done more reps than anybody in the gym, not to brag, but because reps matter when the stakes are high. Okay, now the 30-second exposure test. If you have A, assets in your personal name, plus B, real estate equity, plus C, any personal guarantees, and D, a business that touches the public, you're not a little exposed. You're the legal version of leaving your car running with the doors open. Cliffhanger. In about 3 minutes, I'll explain the 3 levers every plaintiff's attorney pulls: speed, visibility, and control, and how offshore strategy is designed to snap those levers. Okay, so how $5 million disappears, what lawsuits really do. Now, lawsuits rarely take money at a trial. They take money in the middle through pressure. Most high-dollar cases that hit successful people come from a few familiar places: business disputes, employees, competitors, partners, vendors, real estate liability, tenant injuries, claims, partnership fallouts, business, professional liability, auto, boating, accidents, billboards, reputational claims, guarantees, leases, loans, lines of credit, where your signature quietly puts your personal balance sheet on the line. So here's the move. Once a plaintiff's lawyer sees that you have assets, they look for leverage. Now, leverage is discovery, subpoenas, depositions, threats to freeze accounts, liens on properties, and dragging the process out until you settle. And here's a composite case study. Mark, a 52-year-old business owner with rentals, has about a $7.5 million net worth. He has insurance and LLCs, but 2 properties are still in his personal name for convenience. And he personally guaranteed a lease years ago and forgot about it. A business dispute hits, the guarantee turns into a personal case. Mark settles for a number that hurts not because he was wrong, but because he was reachable. So here's a definition that you need. Asset protection isn't hiding assets. It's changing the creditor's options, timeline, and cost before there's a known claim. Okay, now the 3 levers. First of all, speed. Can they freeze or lien quickly? 2, visibility. Can they easily find the assets? Is it visible? Number 3, control. Can a U.S. court force you to hand them over? Offshore strategy is built to break lever number 3. When control breaks, speed and visibility matter a lot less. Cliffhanger payoff coming next. I'll show you why Domestic-only plans often fail at the exact moment you need them the most. Okay, here's why domestic-only protection often breaks. Domestic tools are useful. Insurance, LLCs, good contracts, and retirement accounts. These protections can reduce risk, but domestic tools share a limitation. They live under domestic courts. If a U.S. judge can order you to do something, and you can do it, the court can apply pressure until you comply. And that's the core reason many "I have an LLC" plans crumble under serious threat. Okay, here are the 3 common failure points. First, the personal guarantee trap. You did business paperwork that created personal exposure. Alter ego problem, commingling, weak formalities, or an LLC that looks like a personal wallet. The timing mistake. Moving assets after a threat becomes visible invites claims of improper transfer. Okay, now a word on insurance. Insurance is necessary, but it's not a force field. Policy limits create a target number, and coverage disputes can create delays. I've seen it happen over and over again. It's happened to me. I think that insurance is going to cover a claim, then I found an exception in the policy, and they deny the claim. The smartest approach is layered defense. Insurance is layer 1. Structure is layer 2, so the policy limit isn't your real ceiling, and also the policy exceptions. Okay, here's a cliffhanger. What actually changes the math? In the next section, I'll explain how offshore trusts work in plain English and exactly how you keep control in calm waters. Okay, offshore trust explained like a normal person. An offshore asset protection trust is a trust formed in a jurisdiction with creditor laws designed to resist foreign judgments. And when the trust is properly established and funded before a claim is known, it can do that very well. Plain English mechanism. You place certain assets, often liquid reserves, and investment accounts under a foreign legal system that does not automatically treat a U.S. judgment as a remote control. A plaintiff can still sue you, but collecting becomes harder, slower, and much more expensive. And that matters because most lawsuits are financial negotiations. Your legal structure determines your negotiating power. So now the question everybody asks, does offshore mean I lose control? And the answer is not if it's structured correctly. Here's how we commonly structure the Cook Islands strategy. A Cook Islands trust is at the top. It is the tool that holds just about everything else. A Cook Islands LLC here that will go inside of the trust. So the trust owns 100% of this LLC right here. This is a Cook Islands LLC. In calm waters, no credible legal threat, you, the client, serve as the manager of the Cook Islands LLC. You can direct investments and normal distributions within the plan. When a lawsuit becomes a real threat, our licensed bonded trustee company law firm here steps in as LLC manager. So they replace the manager of the LLC only when needed based on the trust duress provisions and fiduciary duties. So think of it as a home security system. You use the front door daily, but if somebody tries to break in, the system changes what they can do. Okay, cliffhanger. In a minute, I'll give you the single sentence that separates offshore fantasy from offshore fortress, and then I'll show you what should and should not go offshore. Okay, here's the fortress sentence, the 2026 structure map. Here's the sentence. If a U.S. court can reach the control point, it's not offshore protection. It's offshore decoration. So that is the uncommon insight. It's not just where the trust is, it's where the point of control sits when the judge is angry. That's why we generally avoid putting U.S. entities inside of offshore trusts and assuming that that alone solves the problem. A U.S. entity remains under U.S. jurisdiction. Instead, for U.S. operating companies, we often use lawful secured interest techniques like UCC1 lien. So economic value can be positioned as secured obligations payable to an offshore LLC owned by the offshore trust. In normal times, operations run normally. In threat mode, the structure is designed so value is harder to seize. For U.S. real estate, we typically focus on equity stripping rather than pretending the deed is going to move offshore. We use privacy tools like this land trust here that takes title to the property. We have an LLC as the beneficiary of that trust. Then we use equity stripping. Another LLC records a mortgage against the property so it looks leveraged to the hilt. And if needed, we get a third-party lender to purchase that mortgage. We put the proceeds of that mortgage into the offshore trust that we just illustrated before. So when that money sits offshore, the proceeds from the real estate equity, the value truly sits outside of the easy reach of a local plaintiff. And that's the difference between I have entities and I have leverage. Okay, here's your cliffhanger payoff. Now let's get really practical. What belongs offshore and what stays domestic, and how to do this without wrecking your daily life. Okay, so what to put offshore and what not to. Offshore is not a dumping ground. It's a good plan. A good plan is selective. Often, good offshore candidates are liquid reserves, cash and brokerage accounts, investment holding interests, not your day-to-day operating control, excess profits you want protected after proper tax planning and compliance. On the other hand, these things are often better kept domestic with other protections. Your primary residence, U.S. real estate deeds. We use equity stripping and domestic structures. Retirement accounts that already have statutory protection. Anything you need for daily U.S. operations if moving it creates compliance or banking chaos. Now, the most important word in asset protection is timing. The best time to build an offshore plan is when you don't need it. The worst time is after a demand letter, lawsuit, or known claim appears. We can still protect you, but it narrows your options. And because I know you're thinking it, no, it doesn't mean do shady stuff. A professional offshore plan is documented, compliant, and properly reported. And that's risk management for successful people, not a magic trick. Okay, soft resource note. If you want a starting point to understand what a real plan looks like, we have educational material for free at assetprotectionplanners.com. Use it to get smarter about questions to ask, whether you work with us or someone else. And if this kind of strategy-first content is useful, consider subscribing to the channel. So please check right now to see if you're subscribed. If you're not, please do. I keep these videos practical because nobody with $5 million plus has time for fluff. Also, fluff is how you end up owning a decorative trust, and nobody wants that. Okay, cliffhanger. In the next section, I'll show you the 5 mistakes that ruin offshore plans and how to avoid paying for a vault with the back door open. Okay, here are the 5 mistakes that ruin offshore protection. Mistake number 1, waiting until there's smoke. If a claim is known or reasonably foreseeable, transfers can be challenged. Early positioning is the whole game. Mistake number 2, funding the wrong assets. Not every asset should go offshore, and not every transfer method is safe. The plan must match your balance sheet and lifestyle needs. Mistake number 3, weak trustees and weak jurisdictions. You want a jurisdiction with a long track record and a trustee with real fiduciary infrastructure, licensed, bonded, regulated, and accountable. Mistake number 4, leaving the control point domestic. Crazy. Remember the fortress sentence, control is everything when pressure hits. Mistake number 5, no maintenance. Entities must stay in good standing, records must be clean, and the plan must evolve as your assets change. Okay, actionable checklist that you can do this week. First of all, list everything in your personal name. Go ahead and just write it all down, okay? List every guarantee that you've signed. Identify your leverage assets, liquidity, equity, cash flow. Next, decide what portion of liquid net worth should be a protected reserve. Get professional eyes on the structure before a threat appears. Okay, here's a cliffhanger payoff. Last section, rapid answers to the 3 biggest questions, plus a simple start to finish timeline that fits in real life in 2026. Okay, answers plus a realistic 2026 timeline. First of all, is this legal? And the answer is yes when done correctly. Proper intent, proper timing, proper reporting, and legitimate risk management purpose. Next, will I lose access to my money? In calm waters, no. If designed properly, access changes only when a lawsuit tries to weaponize your assets against you. Okay, what does a real plan look like? A simple timeline. Design, map assets, liabilities, guarantees, and goals. Build. Establish the Cook Islands Trust, the Cook Islands LLC. That's what we do. Draft duress provisions. We put those in there. And operating rules. And that's what we put in the trust. Okay, fund. Position the right assets in the right legal tools. Usually liquidity first. Integrate and align domestic structures, LLCs, land trusts, equity stripping where appropriate, and set a maintenance rhythm. Okay, in closing, structure beats hope. You didn't build $5 million plus by accident. Protecting it shouldn't be accidental either. In 2026, an offshore trust strategy is about math. Higher cost to attack, longer timelines, tougher rules, fewer pressure points. The goal isn't drama. The goal is to make your assets a bad target. So if you found this helpful, watch my next video on the difference between LLC protection and offshore protection, because that's where most people misjudge their risk. And we'll see you in the next one.